So I'm with Community Legal Aid. We are a civil legal law firm that helps individuals with specific civil issues. We practice in areas like consumer, which can include credit card defense, bankruptcies, um, loan defaults. We do work with property, including housing, mobile home, land contracts, conditions for housing, landlord-tenant issues, public housing vouchers, SNAP benefits, Medicare, Medicaid, unemployment compensation denials or issues with unemployment. We have a tax attorney that helps with IRS debts to negotiate them or have them waived. And we do LAV, which is legal assistance to victims of domestic violence and sexual assault. So we help with protection orders, divorces, and record sealing as well. We do record sealing, CQEs, which are certificates of qualified employment for people not eligible for record sealing. And we additionally do work with parenthood. So individuals who don't have custody of their children but would like to have visitation, we help facilitate that. We're going to talk about car repossession and what your rights are under the law. So what's the problem? You bought a vehicle, it broke down 3 days after you purchased. You were sold a limit. The vehicle won't pass emission tests, which are required in Summit County and all of Pennsylvania, and Franklin County. The dealer you purchased it from refuses to pay for the repairs and has added costs to your balance. Dealer refused to make repairs, but now refuses. So you initially said he would, but now won't. You never got certificate of title, so you can't register it with the DMV after your temporary tax expired. Your car is repossessed after 2 weeks, and you don't want to give it back because you needed to go to work. And you're still selling. You're still paying on that loan. So the dealer refuses to provide the certificate of title even after you've paid the fullness of your loan. The vehicle was repossessed without any notices, and there was a lawsuit for what was owed on the car, the entirety of the loan, plus what was required for them to repossess the car and resell it. So, what types of sales? Sometimes there's a cash sale. You bring a $1,000, $2,000 cash deposit on the vehicle. So that's governed by the Consumer Sales Practice Act for the state of Ohio. Or you use credit card, or you use a loan, which includes credit cards as well. So you got funding through a lender. That's navigated by Truth in Lending and the Retail Installment Sales Act. So retail meaning you have monthly payments that are required. So what type of car sale did you get? Did you get a new vehicle by someone who's licensed like Ford to sell all of Ford's vehicles new, and so it has a manufacturer's warranty? Or did you buy a used car, or did you buy it from a combination of new and used cars? Because that's going to determine what type of laws protect you there, right? So new car dealers only going to sell brand new cars and certified pre-owned cars. And they always have manufacturer's warranties. So the dealer is going to be responsible, just like the manufacturer, for any defects in that vehicle. And that is a defense to why you didn't pay on a defective vehicle. And you can return it if it's not working, because it's considered unusable goods. So if it's a used car, independent car dealership, they have to register with the state of Ohio. They have to have certain licenses that allow them to sell cars. They have to follow certain laws regarding selling used cars. They have to have notices and plaques about what your rights are. So superstores are the largest selection of used cars. They have the same type of protections as just a small dealership. And the buy here, pay here dealerships, which are common in impoverished neighborhoods, are places where the used car dealership has a contract with a loan provider. And they're going to help you purchase the loan, and you go there to make your payments, and then they transmit them to the loan place. So then there's the private seller, which is like I'm selling it on Facebook Marketplace, send my driveway, come purchase it. So, what types of documents should you expect to have when you purchase a vehicle? A used vehicle order, which basically says the year, the model, the make, the color, any special features inside of it, and what the price is. The purchase agreement, so what you actually purchased the car for, and the bill of sale, meaning you were presented with a receipt. Okay? A retail installment contract is just what it sounds like. It's a loan document that tells you what your interest rates are and what your monthly payments will be. If there are any special clauses that say, hey, you missed 3 payments consecutively, we're going to have an acceleration clause, which means you're going to owe everything at that point, or we're going to default on the loan and we're going to sue you and we'll probably repossess the car. So that's important to know what your retail installment contract says. If there's no odometer disclosure, so that's required under Ohio law. The car that you buy has to say exactly how much is on the odometer. If it doesn't, if it says about or is absent, that's a violation of federal and state law. And it results in fines for the seller of the vehicle. Written warranty, if one is available, or if there's one from the manufacturer. So a used vehicle could technically still have a manufacturer's warranty because they last, let's say, 15 years. And that warrants things like the structure or the engine, things that break down and require a lot of money to fix. And the FTC buyer's guide. So that just means what the value of the car is if you were to sell it, in a normal course of business. Arbitration agreements may be in your documents. May or but not required, and they are present in almost every type of used car that you're going to buy from a dealer, whether it's new or used. And arbitration agreements limit the way in which you have protections. So something goes wrong, your car is wrongfully possessed, or it's defective, meaning it doesn't work after you purchased it, and the person knew that it didn't work. So he or she lied to you to get you to buy it, right? They enticed you to buy it knowing that it didn't work. Then the arbitration agreement says in what way you can fight them. Okay, it says you can't go to court. We have to go through this special process, and that special process basically is set up for the dealer, not the consumer. So the protections are limited. You don't have a judge, you have an arbitrator. Sometimes they require you to pay the arbitration fees. Sometimes the arbitration takes place in another state, and you're expected to appear. So it's just that you can't do it. So one way to fight those is that arbitration agreements in the state of Ohio that basically put all the weight on the consumer have been determined to be voidable. So if you file in the court and they say there's an arbitration agreement, you can tell the court this arbitration agreement is not fair and it's been overturned by this court, meaning the entire state. And the court can then say, no, it's going to stay in my court. Now, arbitration can be avoided entirely by just filing in small claims court. So if the vehicle is less than $10,000, you can file in small claims court. There may be a power of attorney. So if you trade in the vehicle as your down payment, right, so that it's a lower payment and you no longer need that old vehicle, you would have to sign a certificate of title so that the dealership can go get a new title for that vehicle. So here's what a typical buyer's guide is. This is the actual case that I'm currently working on. So it has the make and model of the car, the year, the VIN number. See, there's something scratched out here. I don't know what that is. But it says, as is, no deliver warranty. And then there's an NA next to dealer warranty. And this is NA because there's no warranty, so they don't need to tell us what's covered. And this basically says we don't cover anything. Not anything it's just not covered by this. You're buying this vehicle as is. You're taking it with all defects. Right. Now, so the Retail Installment Sales Act is what I was telling you about. That's when you decide to take a loan to purchase a vehicle, either by buy here, pay here, or you go into a separate and you find your own provider. Like, say you are with a credit union. That's probably the best place to get a loan. Number one, if you're not a part of a credit union and you have poor credit, they'll lend to you still. So we always tell people to go to a credit union. And even if you have a repossession, they'll still loan to you. And they have greater protections. They won't go above a certain interest rate. So the state of Ohio has a cap on interest. Can you guess what the cap is? 25%. That's insane. That's insane. So you figure that's a few $1,000s added to your total bill that you're just paying in interest. So one of the ways we address that is under Chapter 13. If you've owned your vehicle for 2.5 years, we can basically file a bankruptcy and have the court strip the interest to a more reasonable interest, 3%, and strip away any value that is no longer in the car. So really you just do an appraisal of the car, and let's say You have $7,000 on your loan at 18%, but the car is only worth $3,000. Guess what you're paying now? $3,000. So that's one way to avoid an upside down loan, is to put it through a Chapter 13. So this is a used car order. This is another case that we've worked on in the past. So you see the make and model of the car. You see that it says the sales price, 1,000, or actually it's a 7, but it's a little blurry, $7,995. It says there's a deposit of $150. There's a process fee of handling the vehicle, which is $200, and there's a tax of $129, and there's a filing fee and documentary fee of $20. Okay, couple issues with this. You have an odometer reading, but they don't say whether it's actual or approximate. That's a violation. The vehicle was listed at the property for more than this, but the sales price conflicts with that. And the reason it conflicts is that the guy actually had a trade-in. He traded in his old car. So the car dealer, in order to avoid paying tax, lowered the amount that the person was paying him, which is against federal law. This is tax evasion. So you have a processing fee of $200. That's improper. They need to say what that is. It has to have some reasonable connection to what you would expect to do with a vehicle. I registered it. I had to go for emissions test. That's not permissible. Documentary fee. It used to be that a documentary fee was $25. That was the max that you could do it. But after some lobbying, consumer groups raised the amount to $250. And it's just what happens if the car is repossessed. And if it's never repossessed, you still paid it. So it seems like no amount of money, like it's just $250, $250. And if your car is 18 grand, what does that matter? It's a little excessive because you're not going to have $250 in paper copy. That just doesn't make sense. Okay? So cash on delivery, $500. That's inappropriate because it says that it's a loan, right? So the loan says that it's supposed to be $164.68 a month, but he's required to pay $500 on delivery. Why isn't that a part of his down payment? That doesn't make sense. So there's a lot going on with this that's improper. And it also doesn't say whether this deposit is refundable, which is required. So down here, there's supposed to be something that says, this deposit is not refundable. These are your rights under this contract in big letters. It's not contained anywhere on here. So this is a way to avoid a sale of a bad car, just by going over your paperwork to say you didn't comply with any of the requirements that you're going to comply with. And if they don't, not only do you sue them for your actual loss, I lost my job, I had to get rides to work, I had stress from this situation, the actual loan that I took out, I'm still being sued for. That dealership has to get all that money back to you, and then they have to pay Trimble damages, which is for violating the law 3 times the amount of whatever they owe you. And that's cost. So what that means is that it's not included in the judgment. So they can't file bankruptcy on that. They have to pay it. So if your rights are violated, most attorneys will take the case because they get attorney fees, you get Trimble damages, so 3 times the actual amount of damages that you actually incurred. So, common violations. I didn't give you your contract. I was just like, you know what, it's okay, come back and get it, and then it was never available to you. Happens pretty frequently. Failure to itemize charges. We talked about that $200. That's not itemization, because what is that going to? What does it mean? Disclosed terms of sale. Remember that big block letters? Wasn't on that form. Failure to fill in blanks. So you at least have to cross them out. There should be no blanks, because what does that mean? I can go and write something in after the fact. A delinquency charge after it being less than 10 days late. So you can't impose a charge if it hasn't been late more than 10 days. And if you accept a payment after 10 days consistently, you can't have a lateness charge at all because you've given the person the reason to think that you're not going to charge it. So you get attorney fees in the event of a default. There's an acceleration payment, which is what we talked about. You missed a couple payments, so now you owe me everything. No substantially equal installments. We talked about that $500. That's what that means. If you tell me my contract is $169 a month, You can't tell me, but you owe me $500 right now. Doesn't work like that. So it says that you waive your defenses. Legally, you can't do that. You can't just sign a contract saying, I'm not going to get trimble damages, I'm not going to pay it, I'm not going to ask for attorney fees. You can't do that. So inflating, filing, and titling costs, they're set by the state of Ohio. They're at every B&B, exactly what they cost. And it can't be in excess of that. So you can't have, let's say it's $100 to get a new registration. They can't tell you have to pay us $300 because that's not a reasonable tax cost. Charging for service contract. What happens is you can get a company who will warrant your car, a used car. So if it ever breaks down, you've paid this warranty, they're supposed to pay it. But it's part of your car payment. So you give your payment to the loan company or the car dealer, and then they don't pay the company that hosts the warranty. So you really don't have a warranty. You've been paying, but you don't have it. That is a clear violation of ERISA law, and it will result in that dealer or the loan company being responsible for it. Okay. Failing to provide proper notices. We should have mentioned this. By statute, if your car is repossessed, first of all, they have to send you a notice that says, we're going to repossess your car if you don't pay your back payment and one forward payment. They have to give you a clear amount that you owe them to catch them up so that they won't repossess the car. If they fail to do that, that will negate a repossession, meaning they have to get the car back. They can't charge you for wrongfully repossessing it. Ignoring repossession and sales requirements. I had a case where a client had missed a couple payments. She was at her brother's house with her niece, and they hired 2 guys to come and steal the car back. They kept a copy of her key without permission, without her knowing, and then they put a GPS locator on it. That's how they knew where she was. So they came to the house and dragged her 14-year-old niece out the car.
Oh my God.
And the client is thinking the car is being hijacked. So she's running after them, yelling, and she gets dragged by the car. Not severe injuries, but noticeable injuries to her person. The niece has to go to therapy because very traumatic. We sued them. And it was for wrongful repossession because they didn't tell her that they kept the key. And it is lawful to do it, but you have to tell them. They had a GPS, which is lawful, but you have to say that it's on the vehicle, and because you cannot use violence to steal a vehicle, ever. It's a crime. And so the car dealer had to pay because the people he hired did not repossess it properly. And then she had what? Actual damages from hospital bills. The niece had damages because she was emotionally affected and had to continue to see a therapist. So that is all things that are now payable by the dealer in a lawsuit. So you have to also say on a document whether the dealer is maintaining a security interest in it, meaning I technically am the owner of this property until the loan is paid off. It's just like a mortgage on a house. It's not actually your property until you pay it off. It's the bank's property. Same thing with a car. They have to put in the contract that I am maintaining a security interest in this vehicle. And just stating it is not sufficient. They have to put that in the B&B records. So those requirements are supposed to be there. If they do not and they repossess your car, that's an unlawful repossession, and they're in big trouble. Because if your documents didn't contain it, they can't do it. So the Consumer Sales Act protections, basically consumer transactions, specifically for families or personal use. If you're buying a vehicle and saying, I'm going to use it for my lawn care services, then the Consumer Sales Practice Act doesn't apply to you. You don't have these protections. So when you go to buy a vehicle, one of the things you should say is, I'm using this for personal use to travel to and from work and for my family. That's going to trigger them to know that they have to comply because you told them what my intention of this use for this car was. So if they say something like, this was my personal vehicle, I know it drives well, I usually drive it around, it's a wonderful vehicle, it's clean, it has no problems, I just had all this work on it, and then it breaks down, which tells you that they lied, they're in trouble for lying to you. Because they can't lie and tell you that if it's not true. So the other aspect of this is if you sign a contract that says the car is as is, but then the dealer is also saying, oh yeah, it has these issues, but my company will fix it. You can still buy it and just bring it back and we'll fix it. They said as is when you signed the contract. It doesn't matter what he says, it matters what you signed. However, and this is why you should take someone with you when you go buy a car. If someone says they were there and they heard him make these assurances that they were going to repair the car, it doesn't matter that it said as is. It's the lie that becomes the truth. So they still have to fix those issues. And if they don't, that's a violation of the Consumer Sales Practice Act. So, failing to put the buyer's guide on the vehicle. Those papers that are on the back windows of the vehicle, that's the buyer's guide. It tells you all about everything in the car. People usually don't read it. They just go to that number and see how much it's worth. That's required to be in windows. Used car dealerships don't put them in a vehicle, which is a violation. They have to do that. So this is one where they have to tell you minimally what they're going to accept. I'm not going to accept anything below this, right? They can say this is the online vehicle, but because you're in person, it's this price. That's lawful, but they have to tell you at a minimum what the vehicle would sell for in public, okay? Failing to disclose the trade-in allowances. So you trade in your vehicle, but they didn't put how much they traded it in for. So no one knows what the worth of your vehicle was as a down payment, which becomes an issue because if they violate the law, how do I determine your damages if I don't know what they said that they were going to give you for that vehicle? Selling a vehicle at an excessive price. That's against the law. So you can't have a car that's not worth what it's worth, but selling it for a lot more. That's a violation of the law. Failure to disclose the use of a vehicle offered for a manner required. So if I buy a vehicle from Hertz and it was a rental car, you have to tell me that. I have to know that. That's a disclosure that's required, right? If this was a vehicle that Progressive used to send all of his claims adjusters around, you have to tell me that because that's excessive use. And maybe I wouldn't want a vehicle that has excessive use because that means that the transmission is worn, the brakes are worn, the tires may be worn, the fuel ignition may be worn. And so that's something that you need to know to make an informed decision when you're going to buy a vehicle. So failure to get a certificate of title in the purchaser's name within 30 days. That's been expanded because of COVID and you really couldn't do it. And no one really enforces this. Generally, people get a little suspicious at 3 months that they haven't gotten the certificate of title. And oftentimes what happens is a couple things. The dealer didn't get the certificate of title, and now they don't have the paperwork. So that's bad enough on its own. The second thing that would happen, which is horrible, is that it was a salvaged vehicle, meaning it was determined to be totally totaled. It was taken to a junkyard and left there. And then someone went and got it and repaired it and then sold it on a lot. So the title's already been salvaged. And so any future title will say that it was a salvaged vehicle. But you just paid for this vehicle as if it was just a used car, not a salvaged vehicle, which is horrible, but people do it. So we talked about the odometer statement. You cannot have a fake name for your car dealership. Some car dealerships we sue, and so they just change their name. So when you look them up at the Better Business Bureau, you don't know that there have been 1,000 complaints against them because they changed their name. If they change their name, which is not against the law, they have to have a huge plaque when you enter the door that says, I was formerly under this name, so that you can look up the reviews for that former name to know what's going on with this business. So that is a positive thing that exists in the law. So, we talked about the certificate of title, the odometer. This is just basically a federal law that says you can't have deceptive or misleading acts, which is what we talked about. This car is great, it was on my property. There's no issues with it, and then it's salvaged. You can't do that. So unconscionable acts. That's manipulating the person who's buying the car to believe that the car is in good condition. That's telling someone you know has a learning deficiency or who's older and so maybe not understanding very well, leading them to believe that they should buy or purchase a vehicle that is not going to work for them. That is considered an unconscionable act, which is one of the worst things that can happen in the law, is to say that your behavior was so just disgusting that we are saying this wholesale is void. So statutory damages of $200 for the Consumer Sales Practice Act. So if there's no actual damages, but they violated the law by not putting the odometer on there, or putting balloon payments, they would still owe you $200, even if you had not incurred actual damages. Triple damages, that's what we talked about. 3 times the actual damages if the case is prosecuted. So there is what's called a public inspection file. This is an attorney would know this, but it's essentially a file kept by the Attorney General's office of cases that big law for car sales were made in. So if a judge said, you know, as I example, the arbitration clause is unconscionable because it requires you to do all the work as a consumer and you have limited money, that's in an inspection file at the Attorney General's office. So if that issue ever comes up in another case, and they get a copy of that from the Attorney General's office, which is totally free, that's a slam dunk for the case. That's it. You don't even really need to prove anything. You just have to tell the judge that there is a case that controls this, and they violated that case. They are guilty. That is all you need to know. We don't need to go through all this process. So non-economic damages are capped at $5,000. So non-economic are the things like not actual losses. That's the emotional distress, the frustration. Those are non-economic. But actual economic damages, they don't have a cap. If you suffer a great amount of damages, that's what you're entitled to. It just would affect what court you file in. So the supplier, the person who manufactured the vehicle or is selling it, has the option to cure the violations that they made. But they have to tell you that within 30 days of you filing your lawsuit. And you have to respond either saying, I accept it or I do not. And if you do not, but the damages are far less than you would have gotten if you had it settled, you don't get to go back and say, I want the larger amount. So that's the only downside to that. If they're going to cure it, you got to give them the option to cure it. So, as is. We talked about representations about the vehicle. So, common TILA violations. You didn't tell me what the APR is. It's blank. I have no idea what it is. This is a violation. You didn't tell me how much my vehicle that I traded in is worth. Violation. Failure to make disclosures at all. So that big box that I told you has to be very conspicuously on a contract. If it's missing entirely, that's a violation. There are finance charges. So some loans say, okay, it's a $5,000, that's excessive, but let's say $500 fee for having our company create this loan for you. They have to disclose that. Yo-yo sales. You take a car home because the dealer says that it's going to go through, it just needs to come back tomorrow because it's after hours. But then they say, you know what, the deal didn't go through, you got to bring the car back because I'm not going to sell it to you. Can't do that. Can't do that. That's called yo-yo selling.